Jay Preston is a shareholder in the litigation, dispute resolution, transactional, and marijuana hemp practices group of Carnahan, Evans, Cantwell, and Brown, PC. He focuses his practice on litigation of business, trust estate, and real estate disputes, but also handles a variety of transactional matters. With the passage of Amendment 2, Mr. Preston's practice also now includes marijuana hemp-related matters. Carnahan, Evans, Cantwell, and Brown, PC's marijuana hemp practice group represents clients who submitted approximately 200 applications to grow, manufacture, or dispense medical marijuana in Missouri. Mr. Preston is a member of the Missouri Bar, the Springfield Metropolitan Bar Association, and International Cannabis Bar Association. He holds an undergraduate degree in finance from the University of Missouri, as well as an MBA and JD from the University of Missouri. Please help me welcome Jay Preston.
Okay, good morning. It sounds like this thing is working. Well, first off, thank you very much, everyone, for letting me come speak to you today about this topic. As Heather mentioned, this is something that we've dealt with at our firm quite a bit, especially over the last year with the passage of Amendment 2. If you remember back in November, about 65% of Missourians voted in favor of Amendment 2, so pretty overwhelming majority, and as a result of that passage, the state of Missouri has started the process that 32 other states have, which is to introduce a medical marijuana framework to the state of Missouri. As Heather mentioned, we represented probably clients submitting about 200 of the business applications to grow, manufacture, and cultivate. So what I'm going to try to talk to you about today is more kind of an overview, status update of where we are in the process. This is something that all of you will be dealing with, whether it be coworkers, employees that are medical marijuana patients, or potentially, depending on the nature of your business, you might end up doing business directly with one of the medical marijuana businesses. And the point of today is really to kind of clean up a lot of the misinformation that's going up and going around. But as I say that, and I think I just want to mention this since Heather talked about the fact that she'd been to several seminars where she'd heard conflicting information. This is just a rapidly developing area of law. I mean, before December of this year, Missouri didn't have medical marijuana. Now we do. And so everyone's still kind of playing catch up. They're still kind of learning as we go. So that's the point of today's presentation. As Heather mentioned, Carnahan, Evans, Cantwell, and Brown. We have a marijuana and hemp law group, and I am going to, at the very end, talk a little bit about hemp, but for the main focus of today's presentation, it's on medical marijuana. So first, kind of the timing of where we are status-wise in terms of patients. So as I said, when Amendment 2 passed, it had an effective date of December 6th, 2018. The amendment contains a number of deadlines and steps for implementation of the governmental framework. A lot of those have passed. For example, the Department of Health and Senior Services, that's who oversees the medical marijuana program for the state of Missouri. They have drafted, and they are now effective, the regulations they've drafted, and they started issuing patient cards. So as of this summer, people could apply to obtain a medical marijuana patient card in the state of Missouri. So some of the misinformation you may have heard is that no one's going to have a patient card till January 1, 2020. Well, there's about 18,000 people in the state of Missouri right now that would disagree with you because they have cards. So that number is growing quite a bit. The Department of Health is certifying probably about 1,000 patients a week for medical marijuana, and I'm going to talk a little bit about the numbers here in a minute, but it's rapidly growing. There's also patient home cultivation cards. So if you were not aware, under Amendment 2, patients, if they pay an extra fee, follow some extra regulations, implement some security procedures, they are allowed to grow medical marijuana plants at their homes. And the reason that's important is that, as you know, there's not any kind of open dispensaries right now in the state of Missouri. It probably won't be till May or so of 2020. But patients can home grow their own marijuana, so you may have employees right now that have patient cards, that have home grow licenses, and are currently using, for medical purposes, the marijuana they grow in their house. The other part of the equation, we've got the patients on one side, and then we've also got the businesses. So there was, in the state of Missouri, approximately 2,267 applications submitted for the various types of commercial licenses. And those licenses involve the cultivation license, which is to grow medical marijuana. There's testing licenses, that is, they grow it, test it for pesticides and other chemicals. There's manufacturing licenses. That's where you take the product, the medical marijuana flower, and turn it into, probably one of the 8 million things you've seen, whether it be some type of vapor, whether it be some type of food, just various different ways to get medical marijuana into the human system. And then dispensaries. Dispensaries are probably the most unique in terms of the licenses because there's going to be 192 statewide, but they have to be equally distributed amongst the 8 congressional districts in the state of Missouri. So while the cultivation licenses, the testing licenses, and the manufacturing licenses, they might not be centered down here in southwest Missouri. There might be a lot in Kansas City. There might be a lot in St. Louis. There might be some in Columbia. But with respect to dispensaries, which is the retail outlet for medical marijuana, those 192 have to be split equally. So down here in our district, we're going to have over 20 dispensaries spread across our area. And just kind of give you a kind of an idea of where the industry is and how big it's going to be. You can see from these numbers here that the state of Missouri is only going to award a little over 300 of these licenses of various types, but there was over 2,200 different applications for this. If you're not familiar with these, the application process was extremely long, extremely time-consuming, extremely expensive. The application fees themselves, which are non-refundable fees to the state of Missouri, were $6,000 and $10,000 for those, and I can tell you that's really kind of a drop in the bucket for the amount of money that some people spent on this, and there's going to be about 1,800 very unhappy folks probably come December. So this is an unofficial map. This is just something that somebody created by doing a search and finding out all the different applicants in the state of Missouri. But I just wanted to give you an idea of the locations of the different applications. As you can see, it's way too congested for you to really see anything on the screen. But what this picture represents is dispensary applications, manufacturing applications, and cultivation applications. You can see they are largely centered, in the biggest cities in the state, Kansas City and St. Louis, and then, very obviously, right along I-44. But there is a pretty big chunk down here in southwest Missouri. So this, if you're from Branson, if you live down here in Branson, this is a map of the different dispensary applications down here. Not all of these folks will win a license. Most likely, I'm thinking maybe one, maybe two will win licenses down in here in Branson, but it's very likely that one of those locations is where a medical marijuana dispensary will be. You can see similar picture for the city of Springfield. Again, very large number of applications submitted. City of Springfield might get 6 dispensaries, maybe 8 at the most, but it's going to be available. It's going to be prevalent. You're going to have employees who have easy access to medical marijuana and who use medical marijuana. Okay, this kind of is more. This is where the areas of little misinformation and confusion starts coming out. So the Department of Health and Senior Services will start issuing those commercial licenses probably sometime in December. They're mandated under Amendment 2 constitutionally to rule on any license application within 150 days of submission. The applications were all submitted in August of 2019, so under the amendment, they have to get that done by the end of December. But I will also tell you that nobody expected there to be 2,200 applications for this. I think the expectation for most people was anywhere from 1,000 to 1,200, so they're almost double. So while they're constitutionally mandated to get it done by the end of December, if they don't, there's not really anything that's going to happen because all the people can do is sue and say, well, you need a rule. And it's very unlikely people are going to start suing the department to try to get a license, or at least at that point. But so hopefully that'll happen in December. The next step in the commercial process will be build-outs of these facilities. So, licenses issued in December, probably almost immediately or maybe in January, the folks that are going to be cultivating or awarding cultivation licenses will begin construction on their facilities in order to enable them to grow marijuana. Almost all of these will probably be indoors. The state of Missouri does allow for outdoor cultivation, but it's something that's probably more expensive and a little more risky, and so I think almost all of them are going to be indoors. But point is, they'll begin the build-outs, and then the next step in the process is that they have to notify the Department of Health and Senior Services that they're ready to begin their operations, and then the Department of Health, who's going to hire, I think, about 20 to 25 different inspectors to go statewide, will do a commencement inspection. They'll go in, they'll make sure that the build-out facility is, number one, the same as what was set forth in the application that people submitted, and also just more of a check of, make sure that everything looks kosher, that we don't have any kind of issues with contamination, that it looks clean, that it's going to be able to produce a quality and consistent product for medical usage. After that, they begin growing. And this is a little area that, it's just unique, and I've written it down here, this immaculate conception. A lot of questions you hear is, all right, well, before December of 2018, medical marijuana was illegal in the state of Missouri, and marijuana was entirely illegal in the state of Missouri. So where are and as I'll mention, marijuana is still a Schedule I drug under federal law under the Controlled Substances Act, meaning you can't cross state lines with marijuana. So how do people in Missouri get seeds or plants to begin growing? And the honest answer is everyone kind of just turns a blind eye. And it's happened so much in every other state that it's called immaculate conception. I think I've heard different excuses or different versions. I think someone said that, well, it's always possible that, ducks fly south for the winter, and you might find some marijuana in their droppings, or something might sprout miraculously from the ground. Any of those other things. I think what we all really kind of know is that people in the state of Missouri have been illegally growing marijuana. That may be a source of seeds or product, and then people will be crossing state lines to begin their manufacturing operations. But it's going to start, and I think that'll start probably January or February of 2020. And so they'll begin the growing process. Depending on what they do, whether they start from the seed stage or they start from the plant clone stage, you're looking from anywhere from 30, 45, 90 days from the day they start to the day that they actually have a product that is able to be sold to a dispensary or a manufacturing operation. That's the next step. So there is a very rigorous testing process set forth in the regulations set forth by the Department of Health and Senior Services. Every batch of marijuana that is grown, every batch of product that has gone through a processing facility has to be tested by one of the 10 testing facilities that'll be in the state of Missouri. It's pretty rigorous. The testing facilities have to go pick up the marijuana directly from the producer. They get to choose what part of the batch that they take with them. They take it back to their testing facility. They run through to verify that there are either no pesticides, or there's this long list of things with certain quantity limits of, it's okay to have this much, or 0.005 milligrams of this. And then once it's tested, then the cultivator has the authorization to take that to a dispensary. And so that's where we talk about retail sales. From kind of letting me hear, or me telling you the process, you can see that, even if we have licenses awarded in December of 2019, because of the process, because of the build-out that you've got to do, because of the growing process, because of the testing process, and all of that, you're most likely not going to see dispensaries open until, my honest opinion is, probably April or May. I mean, there is a, somebody maybe could do some magic and get it open by March, but I think you're really looking at April and May, and that's really when things are going to pick up. That's why I wanted you to know that date. Like I said, right now there's about 17,000, 18,000 people in the state of Missouri with medical cards. They can get their marijuana either through a home grow or illegally, but it's not going to be as prevalent as it's going to be when the dispensaries actually open, and all you have to do is get in your car, drive across the street. So patient estimates. This is something where you're also going to hear a lot of misinformation because it varies from state to state. And I don't want to say that other people are wrong because this is all largely guesswork. It's brand new to the state of Missouri. Missouri's law is different than Oklahoma's, it's different than Arkansas's, it's different than Illinois's, and Missouri's a different state. So it's really, really hard to get a true, accurate prediction. But what you can see here is I've put Oklahoma next to here because Oklahoma's law in terms of how you get a card, the qualifying conditions that you have for a card, are pretty similar to the state of Missouri. I think Missouri is a little bit stricter, but in general it's pretty close. Oklahoma has about 4 million people in their population, and a little over a year into their program, they already have 200,000 patients. It's kind of been an astronomical number. Nobody really thought it would be near that high, but it has been. It's over 5% of their population and growing. If you compare that to the state of Missouri, if we use kind of like that estimate of 4%, 5%, you're looking between 240,000 to 300,000 patients across the state. That means that if you've got an office of 10, 15 people, you're going to have most likely a couple of employees that are card holders and regular users of medical marijuana. So I don't think there's going to be very busy businesses that don't have an employee that has a card. And I also want to use this to kind of illustrate how big the industry is going to be, at least in my opinion. Most of the research says that in states that have medical marijuana, your average patient is going to purchase between 3/4 to 1 pound of medical marijuana per year. Prices in different states per ounce of marijuana, range from anywhere from $250 an ounce to $400 an ounce. And so when you start doing that math, you start multiplying, $400 an ounce times 12 ounces times 300,000 patients, and you start getting really big numbers really fast. So this is going to be pretty popular. I think it's going to be pretty prevalent. Oh, and actually I should add too, I told you earlier that there's about 18,000 patients with medical marijuana cards here in the state of Missouri right now, and that's increasing at about a rate of 1,000 patients per week. I think that will continue, but I think whenever the dispensaries actually open and people can actually start driving down the street and they see, medical marijuana dispensary, that's when the stuff's really going to ignite. I mean, I think that's when people are really going to start getting their cards, because right now, if you don't grow your own marijuana, there's not truly any point in getting your own medical marijuana card because there's nowhere for you to buy it commercially. But of course, if you use it illegally, you might want your card just as a protection. So, rampant confusion. This is largely this is largely because of the unique issues that we've gotten with medical marijuana. There's rampant confusion. The first one is for the state of Missouri. It's brand new. And so it's, people have other day-to-day jobs. They've got things that they need to do, and they don't have thousands of hours to spend educating themselves on this brand new law. And then also the second part of confusion is, despite the fact that there are 33 states with medical marijuana, marijuana is still illegal under federal law. It's still considered a Schedule I controlled substance with no medical value whatsoever. That causes a lot of confusion, problems, and really it causes some unanswerable questions because you just don't know. For law enforcement, if you follow the news, you've probably seen that even within the last week, there was an incident in the city of Rolla where a medical marijuana patient card holder, marijuana was confiscated. She told the officer that she had a card and she had marijuana, and the officer confiscated it. Now, the officer actually was correct in what he did because the patient couldn't produce her card, but I think even if she had to produce her card, he probably would have taken it anyway. And then here in the city of Springfield, Branson, city of Springfield the other day, There was an incident where someone got pulled over and said they had medical marijuana, and they showed their card, but it was taken away from them because it was of a form that you couldn't legally possess. And when I say that, what it is there's a law in place that says that you can't use combustible materials in your home to turn the flour into something else, and that person had something that was created by combustible chemicals, and you can't have that. But just so there's rampant confusion. I know our firm has tried to educate a lot of law enforcement, and I know they're trying to do the best they can, but there's just confusion on whether you can have medical marijuana and what happens. There's even confusion with attorneys. I myself went to a seminar the other day where an attorney said, like it was 100% true, that no one would have a card until January 1, 2020. Well, that's, like I said, there's about 18,000 people that would disagree with that. So there's a lot of confusion out there right now for the attorneys, employers, and employees. As an employer, oops, did I lose? Oh, no. As an employer, the questions are, what happens if somebody shows up high to work? What if they test positive on a drug test? Do I have to make, and I'm not going to get into the next speaker's area too much, but do you need to make reasonable accommodations for someone to use medical marijuana on the job site? All good questions. Some have good answers. Some are kind of guesswork because, like I said, state of Missouri, it's brand new. Tenants and landlords. I gave a presentation in December about whether landlords would need to allow their tenants to use medical marijuana in the apartments, and just kind of show you how much things change. When I gave that presentation in December, I told everybody I really wasn't sure because there really wasn't any guidance on that. Now that the Department of Health and Senior Services has issued their regulations, my advice on that has kind of changed, and I would tell you that you can, as a landlord, prohibit someone from using medical marijuana in your apartments or any place you rent. It's still a Schedule I controlled substance. It's still an illegal drug. And the law is pretty clear that you don't have to make accommodations to allow someone to use an illegal substance. Now, on the flip side again, why this is ever changing, I think it's the state of, it's maybe Massachusetts or another East Coast state, I can't remember off the top of my head. They have a law in place that says that a landlord can prohibit smoking of medical marijuana, but they can't prohibit any other types of consumption. So if the person had a brownie, or if they had one of the other ways that is not smoking and not causing damage to the apartment or the rented house, they can go ahead and have it. So there's just laws. The laws change all the time. It's continually evolving, and it's just something that we've all got to try our best to stay on top of. One of the areas that I think will really help you as employers is kind of a true understanding of the terminology and the word choice here, because if I've actually spent some time just kind of combing Facebook groups to see what people have to say on these issues, and it's a little amazing how much maybe misconceptions or misunderstandings are out there. You'll hear a lot of people, especially card holders, whenever they're asked about it, they'll say, well, this is a prescription. My doctor told me I can have this, so I get to treat this like anything else. Well, it's unique, and so you can't really do that. It's not a prescription. The way the amendment is written and the way it's set forth, it's not a prescription from your doctor. It's not a recommendation from your doctor that you should or should not use medical marijuana. What it is, it's a certification. And the only thing that the doctor is certifying is that you have one of the qualifying conditions listed in the amendment. That's what they're doing. So they're not actually prescribing medical marijuana. They're not telling you you should take it. They're not telling you you have to take it. They're not going to tell you really anything other than some more general information, because there's a limited amount of medical research on the issue, and a very limited amount. So that's one of the biggest things I would point out to you. If you have an employee come to you and talk to you about it, just kind of keep in your head that this is unique and special, but it's not a prescription. So that's where I want to talk about the patient approval process and how people go about getting a card. The first step is these qualifying conditions. So if you've looked at the amendment before, you've seen that there are a number of different qualifying conditions for medical marijuana. I'm not going to list them all out here, but big ones are PTSD, pain, chronic diseases of certain types, terminal illnesses, et cetera, et cetera. But there is also kind of a catch-all provision of anything else in a doctor's judgment. So it's not a rubber stamp by any means, but it's pretty easy. It's going to be pretty easy for people to get cards. So the first thing that they need to do is go to a doctor and get a certification. If you Google online medical marijuana Missouri certifications, you're going to find a number of websites that offer telehealth visits, meaning you sit from your office or sit from your home and have your interview with your doctor, or they have shops, pop-up clinics, whatnot. And so what happens is the doctor will give you a certification that's given to you, and then you go through the application portal. The state of Missouri, just like the state of Oklahoma, uses an application portal. It's online. You can find it through the Department of Health's website. And what that, it asks a series of questions, asks you to submit your doctor's certification, asks you to submit your payment of your card fee, which is $25 per year for a patient card. And once that's approved, they will issue you a card electronically. And that's why I want to point that out, because you hear a lot of people saying, my card's in the mail. Well, that's not possible because they're not mailing out any cards. The state of Oklahoma does have hard cards that they mail out, but actually the state of Missouri elected to do just an electronic kind of a notification, and when they print it out, you might actually think it's fake. It's just a kind of square that looks kind of like a passport, double-sided, and it has the name, it has the patient number, and that's pretty much all it has. It doesn't have a photo or anything on it. But then, that might sound a little bit crazy, so I want to talk about how the card is actually used whenever it goes into practice, so you don't think that people can just make their cards at home and go and buy medical marijuana, because that's not the way it's going to work. There is a patient database that the Department of Health and Senior Services is creating as they issue these cards. Each individual person has a unique identifier, a unique number. And so in practice, the way this will work is people will go into a dispensary, they will present their card, and then each of these dispensaries are, by law, required to have what we call seed-to-sale tracking, or you might hear it referred to as the statewide track and trace system. Those are not the exact same thing, but they're pretty similar, and the whole purpose is to do two things. It's to make sure that from the seed stage to the end sale stage, that we can track exactly where everything went. That prevents black market sales, that prevents product being taken by employees, et cetera, et cetera. But then so at the dispensary level, they'll do that seed to sale tracking, but they will also have a database that they can access where they input somebody's patient ID number, and what will happen is that person's driver's license or whatever other kind of identification they used to get their card will pop up on their screen, so they'll be able to verify that that person is who they say they are. And then they'll also be able to verify how much medical marijuana they've purchased that month, because there's purchase limitations. The state of Missouri allows for the purchase of up to 4 ounces of medical marijuana per month, or that 4-ounce equivalent in either edibles or what you'd refer to as concentrates. Hurdles and challenges. It's brand new. There's not any Missouri court cases for guidance on what you do if you've got an employee who uses medical marijuana. What happens if you've got an employee who's got a patient card? And so we can look to other states for a little bit of guidance. But as I mentioned, the amendments and the laws in other states, they're different than Missouri's. And so there's no really guarantee how a judge or a jury might rule if you end up in litigation. Statutes and regulations in other areas not designed to address the issue. So the Department of Health and Senior Services has issued their regulations about medical marijuana, but there are lots of other state agencies that might want to set forth some kind of regulations or laws about marijuana usage, about employee protections, about employer protections, etc. And that really hasn't been done yet. So we've all got to kind of keep our eye out to see what changes in the law occur and how that might impact, the way you run your businesses, your employee handbooks, etc. One of the biggest issues, of course, is the state versus federal issue. As I'm sure the next speaker will kind of mention a little bit, you've got things like the ADA, the American with Disabilities Act, and you've got other federal statutory schemes that would apply to you as employers or employees. But under federal law, marijuana is still illegal. And so you've got this just weird dichotomy of something that I don't think anybody really ever envisioned. And, you think about it this way. If my memory serves, to amend the United States Constitution, you would need 3/4 of the states. Well, almost 3/4 of the states in the United States have passed medical marijuana laws. So, you almost have enough people to do a constitutional amendment, but it's still Schedule I drug under federal law. So if it ever is descheduled, probably all the advice that you're going to hear today, the advice that you're going to hear, kind of going forward, if marijuana is descheduled, you'll probably have to throw almost all that advice away and look at it brand new again. But the descheduling of marijuana, there's things that are going on right now. If you're familiar with the Safe Banking Act that's going through Congress right now in order to allow banks to actually safely bank marijuana businesses so they don't have to be all in cash. There's a trend right now, but no idea how fast it'll move. Testing for active THC. So this is probably one of the biggest things for employers. Is unfortunately there are just no good, inexpensive, usable tests for employers to determine if an employee is currently under the influence of medical marijuana. You can test for medical marijuana, but that person may have used 7 days ago, 10 days ago. For heavy users, I've even read that they can stop using for 60 days and still test positive. So there's just not an active and cost-effective test for active THC. People in the industry kind of joke that, especially with respect to law enforcement and driving under the influence, the first person who invents an accurate, cost-effective test for active THC is going to be a billionaire, because every state needs it, every law enforcement agency needs it, and there's a lot of employers that would want to have it. If you have an accident at work and you can actually test someone of, are they high right now, that's a lot different than, that you have an accident at work, you have a problem, they get tested, they come back positive, they tell you they weren't under the influence that day, and it's just kind of a debate. You end up with a he said, she said, where the person says they were fine, and you might say that they were, out of it with bloodshot eyes and were clearly high. Marijuana classified as a Schedule I drug. So I mentioned this before several times, but I think it's really important because this is where a lot of the confusion comes in. It's under the Controlled Substances Act. It's a Schedule I drug, and it has no medical benefit according to that scheduling. That is, it's maybe going to change, but we just don't really know right now. It wouldn't have to change through Congress. That's an executive level decision. So, it could happen tomorrow. We just don't know. But that's where a lot of the confusion comes in and a lot of the issues come in. Employment issues and protections. So this is, right in everybody's wheelhouse and what you're going to have to deal with. The state of Oklahoma, they have what's called the Patient Protection Act, and it gives some protection to employees based on their status as cardholders. Missouri doesn't have it quite like that. It's not the exact same terminology. There's guidance in the amendment. Let me skip forward to this. You probably can't read it, but I think it's important enough. I'm going to say it here. When you look at subsection D, what it says is nothing in this section permits a person to bring a claim against any employer for wrongful discharge, or prohibiting the former employee from being under the influence of marijuana while at work, or disciplining the employee or former employee for attempting to work while under the influence of marijuana. So, there's something straightforward in the amendment that says, hey, this amendment does not give your employees free will to come to work under the influence, and it doesn't give them free will to use at work. But this is the extent of the guidance we have right now. And where that really gets kind of complicated is that whole reasonable accommodation issue is, what do you have to do in terms of a reasonable accommodation for an ADA or a similar type statutory scheme? Well, my answer is kind of a twofold answer, which is, do you have to allow someone to use medical marijuana at work? I'd say the answer to that is no, and I'm pretty confident in that answer. However, if somebody tells you that they are a medical marijuana patient and they have a medical marijuana patient card, you are arguably put on notice that this person may have a disability. And so there might be other things that you should do or might have to do to reasonably accommodate that person. Now, like I said, I don't think that would involve actually allowing them to smoke medical marijuana on the job, but it does kind of, it should kind of perk up your ears, and you need to realize that, you might have just been given notice that someone has a disability. Now, that is one of those areas of confusion. I've heard somebody say before that, hey, if they have a patient card, they've got a disability under the American with Disabilities Act. I wouldn't agree with that. The definition of disability under the ADA is fairly straightforward, and it has to kind of rise to a certain level. There's things where you could be qualified for a card where you probably don't have what I would consider a disability under the ADA. But as I mentioned, rapidly changing laws. If the state of Missouri's legislature decided to pass some kind of protection similar to Oklahoma, where you couldn't discriminate on the basis of being a card holder, that's probably different than the state of Missouri. So, under Oklahoma, I think if you have a prospective employee that applies and tests positive for medical marijuana, if you drug test, you probably can't do anything about it. You probably can't deny them employment based on that positive drug test. I don't think that would be the case in Missouri, but again, it's brand new. But I think what I would encourage everyone to do and really think about is, a lot of employers have issues finding good quality workers. And you're going to have good quality workers that are medical marijuana patients. And so if you take the approach, if you take the position that, well, what I'll call kind of the old school position of, hey, if they test positive for medical marijuana, I'm not going to hire them. I think you're going to end up excluding a pretty good chunk of workers and a pretty big section of the workforce. So, it probably would be a good idea for everyone, if they've got some kind of strict no-tolerance policy, to maybe rethink that, to maybe revise that, probably maybe to make it more of, for what we're going to call safety-sensitive positions. We're still going to have that viewpoint of we're not going to take anybody that tests positive, but for what it would be non-safety sensitive, more of the administrative, clerical, or something like what I do, which is in the office all day, positive test probably shouldn't exclude that person. But that's something for you all to decide. That's something you all to develop within the course of your employee handbooks and your different policies. So last thing I'm going to talk about before we get in kind of the Q&A section is, this was supposed to be the kind of the marijuana and hemp talk. So we've got a little bit of section on hemp and the differences, because it is different. And I think it's important for you to know the difference, because hemp, by its definition, has a minuscule or trace amount of the cannabinoid that we're all familiar with, which is the THC. That's the one where people get, for lack of a better word, high. That's the active cannabinoid. Amendment 2 specifically says that it excludes from its definition industrial hemp with a THC concentration of 0.3% or less. So if it's hemp, it's got less than 0.3% THC, it doesn't fall under Amendment 2 and all the other regulations that are set forth in Amendment 2. It's something separate. 2018 Farm Bill. So this is, again, another rapidly changing and a new industry. Hemp and marijuana are extremely close. You almost need someone who's an expert in horticulture to really tell you the difference, because they're almost the same thing. They're almost like cousins. But in 2018, the United States Congress passed the Farm Bill. What that allowed for was for pilot programs in various states to grow industrial and commercial hemp. The state of Missouri, followed that program, and now they're at the point where the state of Missouri is in the process of setting forth regulations on, not a pilot program, but a full program for the production of industrial hemp, which will, I mean, you'll hear some good debate from folks about which industry will be larger, the medical marijuana industry or the hemp industry. Medical marijuana focused on patients, focused on retail sales. Industrial hemp can be used for clothing, batteries. Really the number of products that it can be used for is almost endless. The ancient Egyptians used it for almost everything. But actually, just as of Tuesday of this week, the USDA released their draft regulations for the growing of industrial hemp from a state-to-state basis. Missouri's got its commercial industrial hemp program. It's got regulations, which they're going to try to mirror the USDA's regulations, but it's definitely in the process. So CBD is kind of that other, three-letter word that you've heard if you've talked about medical marijuana. CBD, or cannabidiol, is a different cannabinoid than THC. So marijuana plants, sativa plants, they have over 100 different cannabinoids, but THC and CBD are the two biggest ones. So, and just kind of show you, kind of the funny nature of this, and again, the kind of confusion. So CBD that's derived from hemp, or CBD that's derived from marijuana. So because you can get them, you can derive them from both. If you derive CBD from hemp, it's legal as a cosmetics ingredient. I mean, you probably see the shops out there that are currently selling CBD. They can definitely do that. I mean, but it's just kind of a little bit of a gray area. But the FDA has sent some warning letters to some producers for making unsubstantiated health benefit claims about it. But here's the difference. CBD from marijuana is still considered a Schedule I controlled substance. So you've got really this interesting scenario of you can have 100% CBD from hemp, 100% CBD from marijuana. They're going to be almost exactly the same thing. One's federally illegal and one is perfectly legal. So just one of those confusing issues. And now, I mean, the question is, and I've got other things I can talk about, but I wanted to make sure that I left a pretty big chunk open for questions, as this is always kind of a hot topic and a confusing topic. So with that, I think we're going to open it up, and Heather's got a microphone, so if people don't mind waiting till she gives it to you to ask a question, that would be great. And then just the one other thing I will say, I'm here to talk about advice from a legal perspective, marijuana update, whatnot. We're not really here to discuss whether it should be medically legal, whether it shouldn't be medically legal, whether there should be adult use and whatnot. I'm going to be here afterwards, so if you want to talk to me about that afterwards. But I think for today, we focus it on kind of an update status. So that's a good question. If you didn't hear it, the question was, is law enforcement going to have access to this patient database so that law enforcement can verify that that person is a legit card holder, since I mentioned that on your card it doesn't have your photo, so you could make it at home. The answer to that is it will, but they don't have it yet. So right now, they're compiling the database. They just started issuing patient cards in the middle of the summer. And I think what I've heard is as of January 2020, they think they'll have that database set up and to be accessible by law enforcement. There's actually something in the amendment that says really the only people who can access that patient database are the DHSS, and then law enforcement can access it for the sole purpose of verifying the person is a legitimate cardholder.
That was actually one of my questions. The other one, which you just answered, like home grown, there's regulations on how many plants. Is that something that law enforcement is going to have information on also? And as a municipality, can you, is there any, I don't know if it's a license or what, for within the municipality also? You know what I mean?
So let me, I'm going to answer the first question, then I might have you restate the second one. I'm not sure I got it. So as far as the home grow, yes, there are set forth regulations. Each home grow operation can have up to 18 plants. They can have 6 regular plants, 6 clones, and then 6 clones, and then 6 not in vegetative state. So I mean, the point is you can have 18 because it grows in a cycle, with the idea that a patient needs continuous supply of their medicine, so that's why you can have up to 18. I think as far as the home grow operations, I mean, law enforcement I think will have the power to inspect and make sure, but really that's actually more of a DHSS thing, because there's certain administrative rules about what kind of security you have to have, how many plants you can have, and whatnot. So I think it'll be more on the DHSS level, although if you have a mass supply of medical marijuana, there's actually something in the regulations that says that if you've got, you're allowed a certain amount, and if you're over that amount, you can get in trouble. If you're way over that amount, the criminal laws that used to apply still apply, and you're looking at a felony conviction. Your second question about municipalities, can you repeat that?
Is more of, is it as actually a individual business? Can the city regulate as far as a license, like a going down to any other business? I mean,
Okay, yeah, I think so. The question is, what can a city do in terms of regulating? I'm guessing both the businesses and then the home grows, or just the businesses? Just the business. Home grow. Okay, so as far as home grow goes, I think a city could set forth probably some basic rules if they can set forth a justifiable basis for them. I was about to tell you that I think there could be a city regulation about the process by which marijuana is turned into a different product, meaning brownies or a different process, but that's already set forth in the DHS regulations about what you can and can't do. So as far as the home grow, I don't know. That's a good question. There's not a flat prohibition in the amendment of no local regulation. But I think the question is, could you come up with a justifiable basis for whatever regulation you're doing? If a municipality passed a regulation that, in effect, didn't allow people to home grow, I think you've got a constitutional violation there, and I think you'd be in real trouble. Hopefully that answers your question.
I had a question from an employer industrial manufacturing angle. So you have an injury on the job, you issue a drug test, obviously it comes back positive for THC. They have a medical card, which we don't know if it's valid or not. Obviously there's going to be a lot of scamming, I'm sure. So from an employer perspective, I understand Missouri doesn't have it figured out yet, but what do other states do in that case?
Well, so it's it's kind of a hot button issue. I read different cases different days, and you get different opinions. I think that the key is here, you've got pretty much every state says uniformly you can't be under the active influence of marijuana at work. That's pretty uniform across the states. But a marijuana test, after an accident, that didn't show that you were actually under the influence of marijuana. So what I've heard from other states, or what I've heard from people who really focus on employment law, and there was a very good presentation by an employment law attorney. I think it's on springfieldmo.gov. He was from Atlanta. I think it's online. You can watch it. I would encourage you to watch it. It's very good. He kind of just talks about the fact that what you need to do in that kind of scenario is have a set forth policy about what you do. You need to sit down there and write, how is this person behaving at work? Were their eyes bloodshot? Do they seem aloof? Do they seem out of it? And it's going to be up to you, if you terminate them or discharge them, to have good records that say, I thought this person was under the active influence whenever this accident occurred. And that's really about all people can do right now. There's just, this has been such a new issue, even nationwide, that there really is a lack of court guidance on it. Legal issues in the states usually take years and years to really fully develop the area of law to answer, most questions.
Just to add a little bit of information to that from the workers' compensation perspective, what we're probably going to see is a lot of one-off scenarios. So if the incident is clearly not the person's fault, regardless of impairment or not, then it's going to sway to them getting full benefits. I think nothing has changed with our workers' compensation law yet. So if somebody tests positive, they could potentially see a reduction in their benefit. But again, they're going to have to come in and do that investigative process to decide if they were under the influence and that caused the accident and played a part in that, or didn't it. So that's, I think, what we're seeing from other states from a workers' compensation perspective as well.
Jay, you mentioned that the terminology and the word choice is now certification rather than a prescription or whatnot, that an individual has a qualifying condition. Have those qualifying conditions been defined? One, do they somewhat also include ADA, which you mentioned about disabilities and such? And lastly, are they state specific?
Okay, that's a great question. So the question really kind of revolved around the qualifying conditions. Yes, the qualifying conditions have been defined. They are in Amendment 2. if you want to go look at them, or they are in the DHS regulations. There's, I think, 13 different qualifying conditions, and they are, some of them are very broadly worded. Like, I'll give you an example. Well, let's compare and contrast. So there's direct ones for PTSD. Like, if you have PTSD, that is a qualifying condition, easily defined. But there's also a qualifying condition that says, if the person has any medical condition normally treated by habit-inducing or addictive prescription medication, meaning most likely opioids, that you can prescribe medical marijuana. So, say I had some kind of terminal, say I had some kind of elbow issue that's haunted me my whole life, and I, used oxycodone all the time because it was in pain. That would be a qualifying condition. So they are defined, but they're very broad. Every state has their own set of qualifying conditions. Missouri's is on the broader side. You've got certain states like Minnesota that have a real narrow list of qualifying conditions, but as a result, their industry is suffering a little bit because they don't really have enough patience to keep the businesses afloat. And then, what was your last? Can you repeat that? State specific? Yeah, so they are state specific. So Missouri does have them. They're defined, and they are state specific. And as far as your ADA question, some of those are probably going to be disabilities under the ADA. Some I don't think are. I mean, if you walk in there and, this is a hypothetical scenario, but you can get a medical marijuana card for anxiety, depression, even pain. Well, certain types of pain are not going to be a disability under the ADA. They've got to rise to a certain level, and like I said, it's going to be fairly easy to get a card, especially given some of the pop-up shops. So I would never say that just because someone has a card, they automatically qualify under the ADA. But I would repeat what I said earlier. If they tell you they've got a card, now you've arguably been put on notice that they might have something.
Hello. I know the CBD thing has gotten real big, and how does that show up on a drug test?
Ooh, CBD on a drug test. This is kind of an off-the-cuff answer, so you might need to Google this after you talk to me. I do not believe it will show up on a drug test because my recollection is that the drug testing that is currently done for marijuana is for the THC. The THC metabolites will stay in the body, they'll stay in the fat, they'll stay in the blood for a certain period of time, a kind of expended period of time. So I think that's the only testing. I do not believe current drug testing tests for CBD. And then kind of to piggyback on that, you'll have people ask the question of, well, if I use CBD oil, am I going to test positive for THC? Well, you shouldn't if the CBD actually is what it is supposed to be. As I mentioned to you, you can get CBD derived from marijuana, and if someone didn't do a good job or didn't care, then you might have over 0.3% of THC in that product, and that might cause you to test positive. Now, I think that's a pretty far-fetched. The CBD has really kind of grown, and it's getting more and more, I don't want to say official and technical, but it's always a possibility.
All right, we have time for 2 more questions. So I have a gentleman up in the front and then a lady right here.
A couple of questions here. If we have somebody that turns in their marijuana certificate into the administration side, are we going to be liable if we go out and try to tell the supervisor for that person that they have turned that in, or are they going to come back and say, well, you shouldn't have shared that? First question.
Can you say that again? I'm not sure I followed.
One of our employees comes in and says, I have a certification for medical marijuana. We feel like the supervisor for that particular person should be notified that somebody underneath their realm is got that certification so that they can keep an eye on them. Are we violating any HIPAA regulations by sharing that information with the supervisor of that person? Secondly, has OSHA weighed in on this yet?
So I can answer the second question. I can give you a better answer than the first one.
Okay.
On OSHA, what OSHA has set forth is those safety-sensitive positions. OSHA and Department of Transportation have kind of taken the more federal approach of, hey, you test positive, we've got these rules that say you can't test positive. So, under definitely Department of Transportation regulations and OSHA, there's not really any protections for employees for being card holders as far as I'm aware. Now, it's always changing, but as far as I'm aware. On that issue of telling the supervisor, I mean, I would want. I mean, this is something that probably I need to check because I don't want to give you any kind of legal advice that's something that's wrong. I think you could probably get away with telling them that they have a card. Anything further than that about what the qualifying condition is that's more of a gray area. I mean, but that's something that actually I would probably need to research is whether inter-company communications about someone's status as a cardholder amounts to a HIPAA violation. My gut says no, but I honestly have not researched that.
One other question is, are the people that have the certificates, are they going to lose their CCWs?
I do not. I believe, I think I actually saw the other day that someone at the state of Missouri had come out and said no. But, yeah, I mean, I think the answer to that is no. They're not going to lose it.
All right, one more question, and then Jay will be available during our break. We're having a few minutes, so you can go and pick his brain after that as well.
Are there state regulations on when we can and can't drug test? And do you know of a reliable resource where we can keep up on if those change?
Did you say protest? I'm sorry, I can't.
Regulations on when we can and can't drug test.
Oh, regulations on when you can and can't drug test. So nothing specific in terms of Amendment 2 or anything new for medical marijuana. If you're talking about the currently existing regulations for when you can and can't drug test, nothing's changed in that part. I don't have a good enough knowledge of that off the top of my head to give you a full answer, but the law did not change when you can and cannot drug test. All right, well, I believe that's the end.
Yes.
Okay.
We're going to go ahead and move on. Thank you. Help me thank Jay for all of his useful information today.